Good afternoon. This is Chavez and Valko, your full service immigration law firm. So we do everything from litigation, deportation, defense to employment based visas and pretty much everything in between that relates to immigration. That is why we are the key to your immigration solutions. I'm Senior Associate Benjamin Hamilton. Here today with me is Associate Andrew Craven. How you doing, Andrew?
Doing good, Ben. How are you?
I'm doing all right. And if you're talking to the two of us, we are talking all things employment based immigration. That is what we do. That is the only thing we do 24/7. So today we are going to be talking about the L visa. So we've previously talked about the L-1A. But today we're going to be focusing on the L-1B. So, Andrew, let's give us the basics. What is an L visa?
So, the L-1 visa allows multinational companies to transfer certain employees from abroad to the US.
So who would be these certain employees?
So, for the L-1A, it's going to be managers and executives, and then for the L-1B, it's going to be employees with specialized knowledge.
And so the L-1Bs are going to be our focus today, right? Specialized knowledge. If you're interested in L-1A, go back, see our previous video where we talk about that. Also, the other thing is that, since we're doing separate videos here, we are going to kind of run through a lot of the basic requirements just of the L visas in general before delving more into the L-1B. So, first, Andrew, give us the sort of full definition of what an intra-company transferee is.
Okay, so the full definition is an intercompany transferee means a foreign national who within the last 3 years preceding the time of their application for admissions into the US has been employed abroad continuously for 1 year by a firm, corporation, legal entity, or parent, branch, affiliate, subsidiary, so on, and who seeks to enter the United States temporarily in order to render services to that branch of the same employer or parent, affiliate, subsidiary uh, in the capacity that is either managerial, executive, or that involves specialized knowledge.
All right. So obviously that's a very long sentence. It is in fact one sentence, and so we're going to need to break that down part bit by bit, right? So the first thing we're going to look at is employed abroad continuously for 1 year within the last three. So what do they mean by abroad?
So that just means straight up outside of the US. So that foreign national has to be physically employed somewhere outside of the US for 1 year within the last 3 years.
We do get questions sometimes about, well, yeah, I'm working for the foreign company, but um, I may be in the U.S. for periods of time. So I guess that kind of leads into the next question is, well, what do they mean by continuous?
So, continuous means without significant breaks during that qualifying year of employment. So, we're talking about significant breaks. So, if you come into the US, say for a week on vacation, that's probably not going to be a break in continuity. But if you come here, say, as a F1 student for a full semester, that's probably going to break the continuity.
Um, okay, so it does need to be continuous, but entering the U.S. as a tourist isn't gonna break that continuous year. You do have to be physically abroad. So if you do come into the U.S. as a tourist, typically we're not going to count that, right? It's not going to break continuity, but we're also not going to count it towards the year. Um, so what do they mean when they say 1 year within the last three?
So basically, you know, within the last 3 years, or if you've already entered the country to work for the same company on a different status, then we're just going to look at the 3 years before you entered. But it does have to be that same company.
Yeah, so that's kind of one of those sort of weird exceptions where, under normal circumstances, they're going to look back 3 years from the time you filed and to see whether or not you worked one full year within those last three. So, hypothetically, if you worked 2 years and then changed companies for a year and now are coming back, you'd still qualify because you have a full year within the last three, even though the last year of employment you weren't working for this organization abroad. But you get this weird exception of, well, what if I came into the US to work for an affiliate or a subsidiary, but just in another status? I came in as an E, I came in as a TN. They say, well, if that's the case, we're not going to count 1 and 3 from when you filed because you may have come in and been working here for, I don't know, 4 years as a TN. If that's the case, if you're working for a related company, then we're going to look 1 and 3 from when you entered. So we're going to start 4 years ago and go back 3 years from that. So we're actually looking at years 4 and 7 to determine whether or not you have the qualifying relationship abroad. So there's always the question of, are we looking back 3 years from when you're filing, or are we looking back 3 years from when you enter the United States? And then that's where it has to be for a related company, and continuity comes in, because I have had people, for example, that were working for the foreign company, came in as a student, and we're here for a year or two. And then when you're looking at, like, you're still in that case looking at 1 and 3 from when you file, and the last 2 years they've been a student, and do you have one full year? And we had a client where we did the math and realized, we only can get to 10 months. And that becomes an issue. So how do we typically, demonstrate that the person meets the continuous employment abroad for 1 year within the last three?
The easiest, best evidence is just one full year of pay stubs. Uh, Pay stubs are always just great evidence to show that period of employment. But you can also use HR records, a formal letter from the HR department that states, the key details of that person's employment.
Well, let's move to kind of the next section here. All right. So we talked about the 1 and 3, but the next big one is qualifying organization. So what is a qualifying organization?
So that means organization, either a U.S. or foreign company that is a branch, affiliate, parent, subsidiary, or some other, form of company.
Okay, well, let's talk about these individually. So what is a branch?
So that a branch is something that is an operating division or office of the same organization, just housed in a different location.
Yeah, so typically a branch is something that is not sort of like independently incorporated, in the United States. Um, all right, so what is a subsidiary?
It's a legal entity which the parent owns directly or indirectly more than half of the entity and controls the entity.
So this is where you always hear about the 51% rule that people talk about, right? Because it says more than half. So it's 50 plus a fraction, which we can distinguish from the e-visas, which literally say 50%. So if we're talking about an investor or a trade visa, the ownership can be exactly 50. But when you're talking about an L, it has to be, 51 or over, to sort of meet this definition. Um, Okay, here we're getting to the one that's a little bit more complicated. Um, but what is an affiliate?
So an affiliate is one of two subsidiaries, both of which are owned and controlled by the same parent or individual, or one of two legal entities owned and controlled by the same group of individuals, each individual owning and controlling approximately the same share or proportion of each entity.
So this is where it gets kind of tricky, right? Where you start looking at, there's two types of affiliate relationships. One is where there's a clear majority owner, and as long as they have the same majority owner, they're affiliates. We see this a lot where there's a parent company with, like a whole some type of parent holding company, and then there's two subsidiaries, and we're moving in between the two subsidiaries, and those two companies are affiliates because they have the same majority owner. Where it gets tricky is where there's no majority owner, and of course, when you read how it's written, it says controlled by the same group of individuals, each individual owning and controlling approximately the same share or portion of each entity. So in terms of the number of individuals, that has to be the exact same. In terms of the exact amount of shares, there's a little bit of leeway there. But in general, if it's like four brothers, 25% each, it should be the same four brothers, 25% each, in order to qualify having the same shareholders. And the one other key word here that people sometimes tend to forget, and we see come up in requests for evidence, is that it's not only about ownership, but it's also about control. So you do have to show that whoever the owner is in fact not only owning but controlling this other company to qualify. So you can be a branch, you can be a subsidiary, you can be a parent, you can be an affiliate. Are there any exceptions to the general qualifying relationship rule?
Yes, so there is one specific carve out for the big accounting firms. And the exact quote is a partnership that is organized outside the United States to provide accounting services shall be considered to be an affiliate of the United States partnership if it markets its accounting services under the same internationally recognized name under the agreement with a worldwide coordinating organization of which the United States partnership is also a member.
So it's kind of an interesting little carve out, but what a lot of people don't realize is these big accounting firms, they think that they're like these big international organizations, but in reality, each one is a partnership. So the partners in the U.S. own the U.S. company. The partners in Germany own the German the German partnership, and they actually would never qualify for an L based on the definition of subsidiary affiliate. So they got, I don't know if they have just enough lobbyists, to be able to get their own carve out. So the PwCs, EYs, Deloitte's, KPMG's can use the L visa. So are there any other rules related to a qualifying relationship or qualifying
Yes.
organization?
Yeah, so the qualifying organization must be doing business both in the US and abroad. So basically, these can't be, just dormant shells. They have to both be actively doing business, which is basically defined as regular, systematic, or continuous provision of goods and services.
And one of the key things is that these relationships, whether it be the ownership relationship, whether it be the doing business component of the qualifying organization, these have to continue to exist. So you can't just say, "Hey, I have this organization in Mexico. I got my L. I've come into the U.S. and now I'm just going to like shut down everything in Mexico." It's like, well, no, the qualifying relationship has to exist, including the organization needs to continue doing business. Um, are there any exceptions to the doing business rule?
Yes, so there is an exception for setting up new US offices.
So we'll get to that a little bit later, but it only applies to the U.S. side, right? So if you're trying to set up a new U.S. company, there is a way to do that. Okay, so now we're going to get into the fun part, which is discussion of the L-1B itself, specialized knowledge. I'm going to warn you, this is one of the sort of just murkiest areas of the law where it's a not very good definition, leading to a very large gray area. You sometimes kind of feel like you're flopping around in quicksand trying to figure out whether or not someone qualifies, which of course leads to a lot of issues with adjudication. Uh, so the L-1B ends up being a little interesting. So there is the actual definition itself, even though it's somewhat ambiguous, is fairly relatively concise. So Andrew, what is specialized knowledge?
It is special knowledge of the company product and its application in international markets, or an advanced level of knowledge of processes and procedures used by the company.
So the first thing you're going to notice there's actually kind of two sort of different definitions within that sentence, right? So special knowledge of the company product and its application, or an advanced level of knowledge of processes and procedures of the company. Now, just to show you kind of how sort of murky and problematic this is, I found an interesting quote from the Department of State. So this is from the federal government that says, The statutory language defining specialized knowledge is not simple or clear. So this is the Department of State telling its own adjudicators, its own consular officers, it is not simple or clear. The phrase specialized knowledge is not otherwise defined in the law, and there have been few administrative or judicial opinions interpreting it. And then they go on to quote a actual court decision. So it's the Department of State quoting a court decision. A decision by a district court in Washington, D.C. was even more critical. Simply put, specialized knowledge is a relative and empty idea which cannot have a plain meaning. So this is the Department of State quoting the district court to say, wow, this is pretty bad. Now, of course, this is a little bit older statement, older decision when specialized knowledge was not defined at all. They've since tried to give it further definition and it's improved, but it's still a somewhat murky area. So, Andrew, talking about how there's kind of like two different definitions there of specialized knowledge. Can you give us a little bit more detail about the first one, referring to special knowledge of the company product and its application?
Right. So when we're talking about special knowledge, the company product, we're talking about distinct or uncommon in comparison to that generally found in the particular industry. So here we would look at the beneficiary's knowledge of how the company manufactures, produces, or develops its product or service. And then they require evidence that the individual's knowledge is distinct or uncommon is compared to that of similarly employed workers in a particular industry.
So again, they've given us some additional detail, which isn't necessarily all that helpful. All right, so let's talk about the second option about advanced level of knowledge. Do you have any further detail regarding that?
So advanced level of knowledge is defined by USCIS as knowledge or expertise in the company's specific processes and procedures that is not commonly found in the relevant industry and is greatly developed or further along the progress, complexity, and understanding than that generally found within the employer.
So if we're looking at these two definitions, there is a lot of overlap. There's a lot of similarity. There are some differences, mainly that the second one is a somewhat higher bar, because you're not setting them apart just from basic knowledge held by others in the company, but also held by others in the relevant industry. So the second one's again, there is a lot of overlap between the two, but the second one is a little bit harder. So we're going to kind of talk here sort of individually a little bit because maybe sometimes the concept itself is so nebulous it can it's sometimes hard to wrap your mind around. So maybe we can talk just a little bit about some of the type of ways we document it, and that can maybe shed a little bit of light as to how we go about describing an L-1B. So Andrew, so let's just kind of start. What's one of the first things that we use to sort of prove specialized knowledge?
So first one would be documentation of the number of years the beneficiary has been using or developing the knowledge.
And that also kind of ties back to sort of, hey, if we were to try to find someone else, it could take us 3 years, 4 years, 5 years to get someone to the same level. And that sort of leads, or that sort of gives, further strength to the argument this is in fact specialized knowledge because it would take so long to get somebody else to the same level. So what else do we, what other evidence can we show?
So we can also show the impact on the U.S. entity's operations that's done by the transfer of the beneficiary.
Yeah, going back to someone that has a very intimate knowledge of of the company's inner workings, or maybe there's a highly sophisticated sort of software product that the company provides, and the impact of having somebody who has that sort of high level of knowledge, can have a really big impact on the U.S. company, both in their ability to sort of train people, and then also their ability to sort of implement these things. So what else do we look at?
We would also look at documents showing how the beneficiary's knowledge has already benefited the international group by increasing productivity, competitiveness, revenue, or what have you.
Well, that one's fairly straightforward. So move on to what's the kind of the next thing that next piece of evidence we can provide.
Patents, licenses, trademarks, or contracts that exist based on the beneficiary's work or their knowledge.
This tends to be one of the ones that's like maybe the easiest and most clear cut to USCIS, whereas like, hey, we got this amazing we patented it. Oh, by the way, we put this person's name as one of the people contributing to it, to be able to show, sort of how high level and specialized their knowledge is. This may be one of the ones that's just kind of the easiest to just say, hey, this is our really cool product. Here's the patent, and this guy's name's on it. So what else can we show?
Correspondence, work papers, or other documentation showing a high degree of sophistication or complexity of the body of knowledge.
Um, and then of course, kind of like the last one that we tend to look at is, sort of, we're talking a lot. This has to do with about where they place within the organization in terms of their knowledge. And so we can also look at pay records, resumes, organizational charts to kind of, sometimes it is very relevant to show, where this person sits within the overall organization to kind of help demonstrate their specialized knowledge. Now, here's kind of an important question, and this is to sort of eliminate some of the stuff that we don't need or USCIS doesn't consider. Sometimes this helps too to kind of know. So what's kind of a factor that's like not necessarily required?
So something like significant cost or inconvenience, although, it can help, it's not required.
Yeah, so we start talking about like, oh, training somebody else, like, you kind of look at how much it would cost versus how much time it would take. The cost factor is not necessarily important. It can help, but it's not necessary. So what's something else that's not really necessary?
It also doesn't have to be proprietary knowledge or unique to the petitioning organization.
Yeah, so you can have, obviously those are like the easier cases where like, hey, the company itself developed something. So like only someone within the company would have that knowledge. But it doesn't have to be that, right? You could have something that's just super duper unique. And this is the guy that they have to bring in to do it. So what else is not necessarily a requirement?
So you also don't need to show a lack of readily available U.S. workers. Instead, the focus is really on whether or not there are so many workers with the same knowledge that it would be considered commonly held knowledge and so not specialized.
Yeah, so it's not like, hey, is there a US worker available to do this? It's whether or not, well, how commonly held is it? So if I can say, yeah, you know, Mark over there, he's ready to go. He knows how to do this. Yeah, well, but Mark's the only one that knows how to do it. So, it's not commonly held if this one guy is the only guy that knows how to do it. Um, it's not a labor certification where you have to like show that you couldn't get a US worker. Um, does the knowledge need to be narrowly held within the organization itself?
No, it just doesn't.
Again, if it is, that way help, but it's not required. Does the person essentially have to qualify as an L1A? Have to be some type of manager or supervisor to qualify for the L1B?
No. So in this case, we're purely looking at that specialized knowledge.
So the Department of State has provided us a couple of examples. Now these are actually kind of old, but they're still somewhat relevant to kind of give an idea of some of the things that they're looking at. Again, leave it to the Department of State. You know, the Foreign Affairs Manual tends to be an actually pretty good resource, just because that is the Department of State trying to give direction to their officers, and they tend to do it they tend to write in an English that's understandable to anyone, as opposed to USCIS, which like doesn't want to commit to anything. It's very legalese. It's very, I want to say everything without saying anything. It can sometimes be difficult to understand. The Foreign Affairs Manual sometimes is the best kind of resource to go to try to understand something, just because of how it's written. Anyway, they provided a couple examples. Let's see here. We got four. Let's see. I'm going to go with the first one. The foreign firm manufactures a product no one else does, and the alien is familiar with the various procedures involved in such manufacture, use, or service of such product. That kind of tends to be the most sort of obvious one, is to say, hey, we're the only ones that do this. This guy knows how it's done. He's kind of one of the only people with this specialized knowledge. So, Andrew, what's our second example here?
So the second one is that the foreign company manufactures a product which is significantly different from others in the industry. Although the product has some similarity to others, the knowledge required to sell, manufacture, or service the product is different from other products to the extent the US or foreign firm would experience significant interruption of the business in order to train a new worker to assume the duties to be assigned to that applicant.
So to me, this is like the first one is like this is when, Apple released the iPhone way back in the day, and it was like this revolutionary. We're the only ones that do it, right? And the second one is like, you know, yes, we manufacture toilets, but we manufacture a smart toilet, right? So it's kind of like it is something that a lot of other people do, but our version of it is a little different, a little bit unique. It's like not everyone manufactures a smart toilet. I don't know why you need that, but there's a smart everything now. And those kind of apply to sort of that first kind of way to be an L-1B, because remember there's two kind of ways to be an L-1B. So our third example kind of applies more to the second, where it says the applicant has knowledge of a foreign firm's business procedures or methods of operation to the extent that the U.S. firm would experience significant interruption of business in order to train a U.S. worker to assume his duties. So again, we're talking about this is someone that has, an intimate knowledge of just how the company works. It's not necessarily like some special product. Because again, we're talking about, where'd it go? Oh, sorry. Special knowledge of the company product and its application. Those first two examples. Now we're talking about, or an advanced level of knowledge of processes and procedures of the company. And so, Andrew, what's our fourth example here?
The fourth one is that the applicant has knowledge of a process or a product which is of a sophisticated nature, although not unique to the foreign firm, which is not generally known in the US.
So you can get some guy that, comes over and says, oh, I don't know, I'm going to cook some, Spanish empanadas, just, something that's, maybe in their home country, not so unique, but in the US market, would be unique. And you would, need to be able to like train people on how to do. So we're talking about L-1Bs in general. Are there any other considerations we need to take in place?
Yes. So the L-1 Visa Reform Act of 2004 basically prohibits the placement of an L-1B at a work site of an employer other than the petitioner or its related companies. If one, the alien will be controlled and supervised principally by the unaffiliated employer, or two, the placement of that foreign national is essentially an arrangement to provide labor for hire for an unaffiliated employer.
So basically, we know that people were using the H-1B visa to place people at third parties. And this has been done for years. The problem is you have an H-1 cap. And so there was never enough H's. And so you saw some of these companies get kind of clever and start using the L, so particularly the L-1B, in kind of the same way. And so then you see that this Visa Reform Act of 2004, where they're trying to sort of curb that and say, no, don't do it. So can you legally place an L-1B at a third party site?
Yes, the key is to show that L-1B will be using the specialized knowledge that served as the basis of the L-1B petition while working at the offsite location.
So we go back to, in general, when you're doing offsite location, you always have to show that they're being controlled by the petitioner, the employee-employer relationship. It continues to exist, that they're not being controlled by the client. And then, of course, in this case, you have to actually show that they're going to be using that L-1B knowledge at the third party location. I'm going to jump here to another question. If I come in on an L-1B and then I get offered some type of promotion, is it possible to change from an L-1B to an L-1A?
Yes, if the job duties of that transferee change from being primarily those of a specialist to those of a manager. In this case, an amended L-1A petition can be filed to obtain authorization for that new position.
Yeah. So the interesting thing is like what you did, how you qualified abroad doesn't match how you qualified here. So typically it's like, well, I was a manager there, I'm a manager here. I'll specialize knowledge there, I'm specialized knowledge here. But it is possible to say I was specialized knowledge there, but here I'm going to be a manager. So that means, well, important question. The cap for L1As is 7 years. What is the cap for L1B?
For L-1B, it's 5 years. So this would actually
So,
be a way.
so that's my question: is this a way when I'm getting close to my hitting my 5 years, I get promoted, I change to L1A, and I get my extra 2 years? Can I do that?
Yes, but the key is timing. So you can do that as long as the employer files that amended petition to change from L-1B to L-1A no later than 6 months before that worker reaches the fifth year of their L-1 status.
So basically, if I show up and I say, Andrew, I cap out tomorrow, can we file a change to L1A today? The answer is
No, you need to go back in time 6 months and then ask the question.
that is the correct answer. So now we're going to talk a little bit just about the the beneficiary, right? The person who's going to be coming over, right? So obviously we have to show that they've worked for 1 year within the last three and all of that. Is USCIS going to demand sort of evidence that they're qualified for the position?
Yes. So in that case, we would want the person's prior education, training, employment, and all of that has to qualify them to perform the intended job. However, that work doesn't have to be the same work that they were doing in the foreign country.
Obviously, this question is a little bit more relevant to the L1A because for the L1B, it seems kind of like it would automatically be part of the case that this person has the education and the experience to do the job. It seems like it's a little bit more inherent to an L1B, but it is specifically stated in the regs. So if you like forget to include like a resume or a degree or something, you can get a request for evidence about it. Must the beneficiary demonstrate non-immigrant intent, like when they apply for a lot of other visas, especially like the tourist and the student visas?
No. So unlike those, the L is a little more like the H-1B in the sense that it is a dual intent category. So you can come here as an L and also be going through the process of trying to get, your green card.
What I love to tell clients is that with the L and the H, if it gets approved and then you go to the embassy to apply for your visa, and then during your visa interview, they ask, do you intend to apply for a green card, when you get to the United States, or apply for residency? You can say, hell yes. The second I get there, I'm applying for residency. Doesn't matter. It's not relevant. H's and L's are allowed dual intent. That doesn't mean you can't apply for residency if you're in another category. It's something that we hear a lot, like, oh, I'm a TN, I can't apply for residency. It's not true. You just have to manage the process a little bit more carefully. But yeah, that's one of the upsides to H and L is the dual intent. So are there any other special considerations regarding the beneficiary?
Yes. So if the beneficiary is an owner or a major stakeholder of the company, then the petition must be accompanied by evidence that the beneficiary's services are to be used only for a temporary period, as well as evidence that the beneficiary will be transferred to an assignment abroad upon completion of those services in the US.
It's a little weird. It allows dual intent, yet if you're the owner, you have to like provide this little extra statement. I don't know why that's in there. It doesn't make any sense. It doesn't really stop you from doing anything. All it means is that if you're an owner of the company, we include this a little bit of extra information regarding, how long you're going to be here, who's going to replace you while you're gone, and when do you intend to return. But of course, that doesn't preclude you from filing for residency. So now we're going to come back to one of the things we discussed before about doing business is that it is possible to do an L where the U.S. office is new. where it was just formed. So, um, what is considered a new office?
So, a new office is an organization which has been doing business in the United States through a parent branch affiliate or subsidiary for less than a year.
Are there any special qualifications for a new office?
Yes, there's three. First one being that there has to be sufficient physical premises to house the new office. That has to be secured. So you have to have some kind of a lease or have bought a building. Number two is the beneficiary has to have been employed for one continuous year in the 3-year period preceding the filing of the petition in an executive or managerial capacity. And the
Or
proposed
specialized knowledge?
or specialized knowledge in this case. And that employment has to have involved, that specialized knowledge for the new operation. And then finally, the intended United States operation within 1 year of the approval has to be able to support that employee.
So you have to meet the 1 in 3 year requirement. Okay, that's standard to all L-1Bs. The sufficient physical premises, so it's like a lease agreement or some type of land purchase agreement or whatever, is mandatory. You have to have it. It's kind of a weird, but whatever. Um, these were laws written in the 90s before we work in those types of situations, but those are accepted. The shared spaces and whatnot. Okay, so the third one's kind of like the most, I think it's at the heart of the new office, right? So it says the intended U.S. operation will, within 1 year, support a manager, executive, or specialized knowledge. Is there any further detail regarding that third point?
Yeah, so there's three more points to the third point. So first, you have to provide information that the proposed nature of the office, describing the scope of the entity, the organizational structure, and its financial goals. Then there's the size of the United States investment, the financial ability of the foreign entity to remunerate the beneficiary and commence doing business in the United States. And then finally, number three, we got to provide information, the organizational structure of that foreign entity.
So we want to see your business plan. We want to see that you have the money to follow through with your business plan. And then, of course, we want to just kind of see the overall structure. Where does the U.S. company, where does the beneficiary sort of fit into the overall organization? Pretty straightforward questions. To be honest, getting new office Ls approved isn't that bad. It's the extension that's problematic, especially for the L1As, right? Because when you're applying for the new office, you're having to prove that you will be a manager in a year. But then when you file the extension, you have to now prove that you are a manager. And so it's that extension usually that's the kind of difficult part. All right, so let's talk about this sort of process of applying for an L visa, and this is pretty much the same for an L1A or an L1B. So hey, look, I think I qualify for the L1B. Can I just go to the U.S. Embassy or consulate and apply for the visa?
No, so you can't go straight to the consulate. You have to first submit your detailed application to USCIS.
There is one exception to that, but we will get to it next. But in general, no, you have to go to USCIS first. And that applies to actually most visa categories like H's and R's and O's. I mean, the only really exceptions to that are the investor visas and the TN, which you can, well, I guess E3, and there's a couple in there. So if I submit an application to USCIS, how long does it take?
Generally about 4 to 6 months. There is premium processing available if you're willing to spend just $2,500. Then they'll do it within 15 days.
Yes. It's important to say that $2,500 goes to the government. It does not go to us. You're paying the government to do it 15 days. And if you're wondering, I heard about a lower number. You are right. It was half that up until October of 2020. And then Congress raised it to $2,500. So if USCIS approves my application, how long is it for?
So if you have an existing company, the initial approval is going to be for 3 years. And if it's a new office, the approval is going to be for 1 year.
And so can I file an extension?
Yes, so you can file to extend it for 2-year increments until you've hit the 5th year for the L-1B.
So it's 322 or 1222, unless maybe you're able to then swap to an L1A manager and get those last 2 years. Um, so once I have my USCIS approval, now can I apply for the visa?
Yes, so at that point, you can apply for the visa, and you can also apply for the visa for your family. So that's going to be spouse and children under 21, and they would get what's called the L2 visa.
So if my family comes in on the L2 visa, can they work and go to school?
So all the family members can attend school. The spouse can request work authorization after you're in the US.
Well, let's say I'm in the US right now. Maybe I'm a student. Maybe I'm here as a tourist. Can I just file a change of status here?
Yeah, so in general, there are certain exceptions, but if you've already in the US, then you can apply to just change status. Those exceptions would be if you entered on a visa waiver, for example.
Yeah. So if you're here on ESTA, like, for example, most of like European countries, you don't need a visa, which is great. But the downside is you cannot file a change of status. So you would have to submit your application to USCIS, return to your home country, get the visa, and then come back to the US. Are there any exceptions to people having to file first with USCIS? There's a big exception we're going to get to in a second, but are there any little exceptions?
Yeah, so Canadian citizens can apply directly with CBP when crossing the border or going through the airport. I will say though
Okay.
that CBP hates that.
Here's my important question. Do we like CBP?
That I mean, I wouldn't say that if they're watching, but no.
In general, CBP are maybe the worst of all of the bodies we deal with when it comes to adjudicating cases. They perform a lot of other functions, which they do fine, but when it comes to like having to sort of review and adjudicate a case, they kind of tend to be the worst. But yes, hypothetically, if you are from Canada, you can kind of apply at the border. And if it's a strong case, then go ahead and do it. If it's a nuanced case, like I'm a functional manager or something weird, or then you might be better off just pre-submitting the case to USCIS. That way, you get the USCIS approval. So when you show up at the border, you got the approval in hand. You've removed the adjudication from CBP, right? You've got it done by USCIS. And we did that, for a client recently that was applying as a functional manager. We're like, no, this is just too risky for him to like potentially getting denied at the border or getting hassled. Let's just submit it to USCIS. We did get an RFE, but we did get it approved. And then that way he was able to just enter, no questions asked. So we're going to move to the big exception now. I've heard my employer has a blanket L. So what does that mean?
So a blanket L1 petition is a single petition that can be approved for a large multinational company. And this eliminates the need to file separate L1s for each of the employees. So you can use this blanket L approval to skip USCIS and then just apply directly for the L1 visa.
The requirements are fairly high, right? You have to have been doing business for a year. You have to have 3 or more domestic or foreign branches, and you have to have annual sales of 25 million, a U.S. workforce of 1,000, or have received at least 10 individual L approvals over the last year. So these are for big companies. But the idea being is you can say, hey, USCIS, I'm Google. I'm big. I'm awesome. You know who I am. So you know what? I'm going to come in, get this blanket approval. So now you're no longer going to keep asking me about the company, right? You know who we are. You know who all our subsidiaries are. So now the only question is, does this individual who's applying qualify as a manager, specialized knowledge. So basically, you no longer have to submit anything to USCIS, right? You just send a copy of the blanket approval to the employee, with their application packet, and they just go directly apply for the L at the embassy. So there's nothing needs to be submitted to USCIS. So the quick question is, when a company first gets an L blanket, how long is it good for?
It's good for a year initially.
And if they file an extension, how long is it good for?
Indefinitely.
Indefinitely, as long as you use it.
Right.
If you don't send anyone over, you can lose it. But as long, so you could, Microsoft hypothetically, I guess, could have gotten a blanket L back in, I don't know, 1990 or something. And as long as they keep moving people around, they would have never had to have renewed the blanket L. Well, off the extension. Got some interesting fun facts for you, Andrew. So I pulled some data from USCIS about L's. We're going to see if we can kind of stump you here on some fun questions. Question 1. Which has a higher initial approval rate? L visas or H visas? H-1Bs versus
Higher.
L's. Which has the
I'm
higher initial approval rate?
gonna guess H's.
You are correct. On average here by about a full 10 percentage points. So the initial approval on H's is, in the mid to high 80s. And on L's, it is in the sort of mid to low 70s. So H's have a higher approval rate than L's. Here's my second question. For L's, RFE issuance rate. We're going to do an over-under here. Over-under here. This is just for L's. RFE issuance rate. Over-under 50%.
I'm going to guess over 50%.
You are correct. In 2020 Q2, 53%, over half of all L's got requests for evidence. That's been one of the big things I noticed since I started. I remember way back in 2010 seeing L's that had been filed previously, like, hey, here's the one that was approved as an example. And man, they were like nothing, right? I mean, they were like 50 pages. And these things were getting approved. And then you saw in 2011, 2012, USCIS just started ramping to now you submit an L and it can be 1,500 pages. It's ridiculous the amount of stuff they want you to document. These days, it's not just about they want these super detailed job descriptions and then job descriptions for the subordinates and degrees for the subordinates. I mean, it's absolutely insane. All right, man. We'll give you a cookie if you can get this one right, because this is a very specific question. Which company has the most L's? And it's not even close. And let's just say it's in the same universe as H-1Bs.
Ooh, it's going to be one of the big tech companies. I can feel it. I really want to guess Google, but I'm worried it's going to be Amazon.
Oh, you missed the mark. Amazon is number 3. Number 1 is Tata, with number 2 being Infosys. But Tata has total approved petitions, I think this was for 2019, was 1,500, fiscal year 2019. Number 2, Infosys, was only 500.
Wow.
So obviously what we saw is the big Indian IT companies, right? They wanted to use tons of H's, but there's a cap. So what were they doing? Well, they were hiring these people in India and then just transferring them as L-1Bs. That was their kind of way to kind of get around the H-1B cap, was to use the L-1B. And then, of course, that's why we talked about there was that L-1 visa reform law trying to kind of curb third-party placement. So one was Tata, Infosys, then Amazon, then Cognizant, then Deloitte. Let's see what else we have down here. Tech Mahindra, there's a lot of HLC America. There's a Wipro, Capgemini, Gemini, obviously. So we're seeing a lot um, of the Indian IT companies, but we also see. Remember, we were talking about the specific carve out for our accounting friends. We do see Deloitte up here in the top 10. EY is in the top 10. Um, so these are some fun numbers. What I think is interesting is they have a breakdown by company by title. Of course, the L1As, 95% are executives or managers. I don't know why they bothered breaking down the L1As. What do you think would be the number one category for L1Bs? Beneficiary occupation.
The
L1B
specialized
beneficiary occupation.
knowledge, we've established it's mostly Indian tech companies and then some of the larger US tech companies. Uh, Lead software engineer. That's a
I'll give it to
terrible
you.
guess.
I think you were actually overly specific, so we'll give you that as a subset of the actual one. Here, it's just science technician. I'm not exactly sure what that's supposed to be, but I think that includes all of the IT and computer and technical related. That's 23%. So it's actually not like overall. Let's see if you can guess number two, and it's right behind it. It's 20%. What's the number two L1B occupation?
Well, we've
I'll give
already
you a hint.
covered.
I'm gonna give you a hint. There's the two ways to become an L1B, right? It lines up more with the second way to become an L1B.
I mean, I was sitting here thinking like if we've covered science and technology, then these would just be engineers and it would be vague at that.
I think all those fall under the science technician. All of the like computer engineers, computer science, information technology. I'm giving you a hint, man. Think about the second way to become an L1B. Number two profession is management support,
Yeah, I was never gonna get that.
meaning unique knowledge of the company's not of a product, but of the company's processes. So it's someone kind of internal to the company.
I mean, that makes sense, but I've
Management
never heard of
support.
the position management support. I'm never at a bar asking someone what they do, and they're like, "Oh, I'm management support."
Well,
But
there's
I've
like
also never heard I'm a
there's like
science
30
technician.
occupations here. Um, although mathematician is like 14%. That's an interesting one. Um, so I want to see if there's an overall number here at the bottom. Oh wow, this is a long, long, long list. Let's see if there's a total at the bottom. Apparently, oh, here we go. Okay, let's see if we can get. Let's see if we can get this. We're gonna do like Price is Right, closest without going over. Price is Right rules. Fiscal year 2019. How many L1 visas? Actually, I'm going to be specific here. This data all comes from USCIS. It does not include blanket Ls. This would be
Oh,
cases submitted to like USCIS. I don't think it includes blanket Ls. I could be wrong here. Closest without going over Price is Right rules.
I'm gonna say around one no 75,000.
Ooh, you should have gone with $1. Um, it was a little over 30,000.
Okay.
Like I said, I don't think this is USCIS data. I don't think it includes um, blanket petitions, ones that apply just straight at the embassy and don't go through USCIS. It was 30,000, a little over 30,000. So anyway, you can see that the L approval rates are a little bit lower than H's, but it's still in the 70%. You your likelihood of getting an RFE is literally 50-50, which is higher than an H. But we do see a lot of these. I mean, again, there was over 30,000 in fiscal year 2019. Again, that doesn't include all of the blanket ones, which the blanket ones, I'm willing to bet if we had data on that, it would show that their approval rates are higher.
Yeah.
For the, because again, if you're like, oh, I'm a blanket for Microsoft, they don't have to ask a whole lot of questions. So anyway, I guess this concludes our discussion of the L-1B visa. Again, if you're looking for the L-1A, we do have another video covering that. Otherwise, we are very grateful for anyone who watched. Hope you learned something. If you have any questions, right, give us a call, give us an email. You can go to our website, book a consultation. We're here to answer any questions. We do have a great app that you can download, Law Pilot Guardian. It is free. It does have a lot of useful information there about know your rights. It's also in English and Spanish, and we're adding features as we go. But otherwise, we'd like to thank everyone who has watched this video. Andrew, thank you for your time, and stay tuned for our next video. We hope to get through pretty much all the visa categories and then all of the employment-based residency categories. So stay tuned. Thank you.